All right.
Perhaps in a more simplified manner, can you tell us what Mr. Nygard admitted to discuss today?
Well, again, the process, and I don't want to overly complicate the process because we can get too lawyer-like and try to break it down into its phases. But what was said is very clear. The first, what happens is an extradition request is initiated. Ultimately, what's called the International Assistance Group, on behalf of the minister, specifies a comparable offense upon which extradition or committal for extradition will be sought. There were 5 offenses in the American indictment. One of them, and I referred to it in the hearing, and that's racketeering, has no Canadian comparable. So, quite frankly, they're precluded from extraditing on that charge. There is no Canadian comparable offense. It's not conduct which is criminal in Canada. The other 4 offenses all, at least theoretically, have a comparable, where conduct in Canada is also criminal conduct in Canada. So they could have specified 4 offenses in the authority to proceed. They specified 1 offense in the authority to proceed. And that limits the judicial filter, the screening process that we were part of today. So the screening process could only be on the 1 offense, so that any challenge to the other evidence relating to the other offenses can't be made here. And so the threshold for extradition is a very low threshold. It's the same, and some of you who have covered criminal courts, it's the same standard as committal for trial at a preliminary hearing. Same standard. And quite frankly, collectively, I think we have about 150 years of experience in front of you. We can probably count on 1 or 2 hands the number of times in our collective careers we've had discharges at preliminary hearings because the standard's so low. So all that was conceded today was, because of this low standard, there is sufficient evidence based upon extradition law to warrant a consent to committal on the 1 charge. We will then go to the next phase, the ministerial stage, and we'll argue to the minister, there was enough on the 1 charge, your people chose only 1 charge, didn't give us the opportunity to challenge whether there was evidence on the other charges. And fairness dictates that you should only send Mr. Nygard to the United States on the 1 charge. Now, 1 charge means 1 charge, it doesn't mean 1 count. In other words, you can have multiple counts of the same charge, but 1 offense, and that's the offense of trafficking persons. It doesn't complicate this aspect of it. The minister will have to make a decision as to whether or not he will await the outcome of the Canadian charges before he extradites, or whether or not he will seek assurances from the United States that once they deal with the charges in the United States, they will expeditiously return him to Toronto under transfer of prisoner treaty or some of the mutual legal assistance treaties that we have with the United States, and that once they've dealt with them there, he'll be returned to Toronto. Those are 2 options that the minister has, whoever the minister might be, because right now we don't have a Minister of Justice.
What's Mr. Nygard's response to the charges in Toronto?
There, as in the past, Mr. Nygard denies any allegations of criminal conduct. He denies any suggestion that he engaged in conduct for which he should be charged criminally. And we also point out, and quite frankly, it hasn't been, and if you're taking this as a criticism of what I'm about to say, of Canadian coverage, very seldom has Canadian coverage dealt with the expose in the New York Times, where very clearly and unequivocally the New York Times found that his protagonist in the United States, his neighbor from the Bahamas, in some very, very insidious ways, has bought evidence, created evidence, encouraged deceit and corruption in terms of the investigation of Mr. Nygard. That's what the New York Times found. And quite frankly attributed, when they dealt with some of the people who allegedly were so-called victims of Mr. Nygard, they retracted. And that is part of an extensive investigative report from the New York Times. And that, to some extent, outlines the defense position on all of the allegations.
So more than 100 women have come forward. Is Mr. Nygard saying they're all lying?
You know something, I'm not going to get into, and I'm not sure where you get the more than 100 women have come forward. I don't know the basis of that. Certainly in this extradition hearing and the record of the case, there were allegedly 7 people who are chronicled. In Toronto, I believe there are 6. But aside from that, those are the only charges that he currently faces.
Mr. Nygard be applying for bail?
We'll consider that, having regard to the previous hearings and the view taken by the Manitoba Queen's Bench and the Manitoba Court of Appeal. We'll have to be a bit circumspect about that.
Can you talk about Nygard's health now? I mean, he's not 80. He's going to be facing potentially, what, years, months?
Well, you saw him today, yes. You saw him today, and while he was masked, as he should have been, his health has deteriorated. You're right, he's 80 years old, and this has taken a tremendous toll on him. So we can only assume that he's not going to get any better, at least in the short term. And but this whole process was about him having a trial in the United States, and his hope and ours is that he'll be vindicated. That's the reason that this process was expedited here in Winnipeg. There were hearings set for November, as you may well know. There were 4 days set. The matter's brought forward so that he can get on with his fight, and his fight will be in New York. He'll be arguing that there isn't evidence beyond a reasonable doubt and that he should be found not guilty.
Will Mr. Nygard remain in Manitoba while the Justice Minister reviews the extradition?
Yes.
Is the trafficking in person. So you're going to argue that if he is to go to the U.S. to stand trial, that it should only be on that charge?
That's international law. That we don't have to argue that. It's called the law of specialty. So the requesting state in international extradition law can only try the person extradited on the charge upon which extradition takes place. They're limited. They can't add charges. They're limited by international agreement and by the Extradition Act and by the treaty between Canada and the United States.
More than one charge to extradite on?
Absolutely. They chose one charge. They had the, they could have picked up on, we say they could have picked up on the other, they could have picked up on 3 of the other 4. They couldn't have picked up on the one, the racketeering charge, where we don't have a comparable.
Other than the new charges in Toronto, do you see any situation where the Justice Minister wouldn't agree to an extradition?
Well, there are some assurances that we're going to request of the minister. For instance, as you pointed out, he's 80, he has multiple health issues, and if any of you have been aware or read of the horrible conditions of what's called the Metropolitan Detention Center in Brooklyn, New York. They've closed Rikers because of the intolerable and inhuman conditions in the other detention center in New York. So we're going to seek assurances that Mr. Nygard, should he be extradited, is placed in a place of detention where his life isn't threatened by the conditions of incarceration, which, quite frankly, is really a judge in New York, a senior judge a retired senior regional judge in New York, she referred to the conditions at the MMC and the MDC as inhuman, and that the places were run by morons. And that was in a very public judgment in New York. And there's sewage in the cells. There are really conditions that we ought not to tolerate in terms of international standards.
How soon, Mr. Nygard, what are we looking at in terms of timeline?
We're going to make our submission to the minister very soon, hopefully within the next week, 10 days. And the government then has 30 days to respond to those submissions, and then the minister has another 30 days or so to make a decision. Hopefully during that process we'll have the identity of the minister by then. So do we think that this process could be over by the end of the year? We would hope so.
So just to be clear, though, with this,
Sorry, you mentioned that Mr. Nygard sort of wants to answer to these charges. Will you be submitting? Will you be, filing for? Will you want him to stay here, or will you be filing against the extradition, or does he? It sounds like he wants to face these charges.
He wants to face these charges. The only place that you can be vindicated is in a trial. You can't be vindicated on an extradition hearing. I think everyone's painfully gone through that for a number of months, and perhaps the last 1,000 days in Canadian judicial history. But having said that, this process can be an extended process or an expedited process. When you're 80 years old and in custody, it ought to be expedited.
so you aren't going to contest that he should go to the U.S., but you're going to argue the conditions under which he should.
Conditions end that he only ought to be sent to the United States on the one offense.
Have you heard from Toronto Police? Any of you?
Yeah, I have.
Yeah.
I've talked to him.
Has he been formally charged?
Have they released a statement?
There's a warrant issued.
Yeah. For a warrant to be issued, there has to be an information sworn. You can't issue a warrant for arrest without an information.
And what happens next in that process? Will they have to?
We're trying to work on it.
Yeah.
All right. We currently are just considering the various options. No, it'll be the minister's choice. Be the minister's choice.
Thank you.
Okay.
Good morning.